again. And welcome to today's first session with a focus on how SMEs can use and benefit from IPR. Our intention is to present you with the business perspective, and despite having legal backgrounds, both of us, we have decided not to provide you with too much about the legal framework. Instead, we want to attract you to the fascinating world of IPR through practical examples of how different types of knowledge-based assets can boost your business. But first, a brief presentation of who we are. My name is Lars Holm. I am Director of Better Regulation, Entrepreneurship and SME Policy at the Confederation of Danish Industry. Until recently, I was also responsible for IPR policy, and previously I have also worked as Deputy Director for IPR policy at the Danish Patent and Trademark Office. Now, Christina.
Yes, my name is Christina Wainikka, and I'm the policy expert of intellectual property at the Confederation of Swedish Enterprise in Sweden, and I've been here since 2018. The Confederation of Swedish Enterprise has 60,000 member companies, and as you can understand, that range from all types of businesses to all types of sizes, including many SMEs. I have a background as a researcher, and I've also been on the supervisory board of the Swedish Patent Office since 2008. But apart from that, I actually do have experience myself from running a really small company. Back to you, Lars. No, next slide, sorry. So, one of the first cases that we're actually going to mention is a Danish case, the Pandora case. So the Pandora case is actually something that hit the press in Denmark some years ago. And as you can see, perhaps I have a nice bracelet on with different charms. And that's what Pandora are famous for. They make jewelry with different types of charms. And what hit the press some years ago was that they had bought the copyright of some beads made out of glass. And the press reacted with, how can you pay 190 million Danish crowns, equivalent of 19 million euros, for the copyright of some glass beads? And comparisons were made to the buy of Manhattan from the Indians. How can you pay so much for some glass beads? But how did the market react? Well, the market actually found the deal to be a good deal. So they didn't react by selling shares or anything. It was a good deal because actually the starting point was that they had a dispute regarding the copyright of these beads. So what can we see from this example? Well, we can actually see the value of intellectual property rights, that sometimes someone from the outside can say, how can something be worth so much? But in a business case, IPR can actually stand for a great point of the value. Now over to you, Lars.
Thank you very much. Well, there are many perspectives on IPR, and we want to present you with some of them. And I think many of you would most likely say that the main objective of IPR is to allow the owner or the owners an exclusive right to decide who can use the subject that is protected. It's not incorrect, but there's much more to it. It's not just a user right. Actually, what you have when you have an intellectual property right is you have an exclusive right for the right holder to exclude or prohibit or prevent others from stealing or copying and using the subject that is protected. And this subject could be a technical solution to a technical problem. This is something that is mostly or most often protected by patents. In some countries, you also use utility models. You also have unique characteristics like words, figures, combination of the two, like slogans, and even specific smells or sounds or colors, and they can all be protected as trademarks. Then you have appearances and forms of a product, or parts of a product, decorations and forms, and they can be design protected.
I cannot hear you, Lars. So I'll take over. So what I heard Lars starting to describe was the different perspectives on IPR. So you can use IPR to create protection through creating an exclusive right, and that right is possible to enforce in court cases. And if you look at that, is one perspective, and that perspective is absolutely true still. But there are also other perspectives on IPR, and I'm right now on slide 5. So another perspective on IPR is that you can actually use intellectual property rights in different ways to create business. So the engine of your business model could actually be the intellectual property rights. And by doing so, you can create something that you could actually sell. From not having anything to sell, what you sell could be the intellectual property right. And if you have something to sell, or you could have a business model centered around intellectual property rights in different ways, then you could also create something that someone would be willing to invest in. And that might sound very abstract, but if we move to the next slide, I'll give you 3 different types of examples. And the first 2, there are 2 different types of exercising. And I'm not sure if you're familiar with these types of exercising, but Zumba is a training concept based on dancing. And spinning is an exercise form where you do indoor cycling. And the difference between the 2 from an IPR perspective is actually when you look upon them, how they are protected and how they can be used through the protection, how the IPR helps building the business model. So Zumba is an exercising concept where you dance. And mankind has been dancing since forever, so there's nothing really new to that. But what they had created, and this was created in South America but has spread out through the world, is that they used the trademark protection. And through having the trademark protection, you can license it. So you license a trademark. So if the gym wants to say, we have Zumba dancing classes, a type of exercise that is to a lot of people more fun than other types of exercising like running. But in order for the gyms to say that they are using that or having that type of classes, they will also have to put the instructors through the right training so that they will lead the classes in the same type of values and so on that the creator had when they created the concept. So it is commercialized through the trademark license. What is the comparison to spinning? Well, spinning started off as someone having a bright idea for indoor cycling and started to create this training concept. But what they failed in doing was to create that strong IPR, leading to that spinning today is a type of exercising. You can go running, you can go hiking, you can go spinning. So it's a general term for a type of exercising. And that leads to that you have nothing to license when it comes to the word spinning. You can't control the training that the instructors have. And we as consumers, when we go to spinning class, they can be very, very different. As compared to Zumba classes, you know what you get. So that's one example of how you commercialize through the intellectual property rights. And then we have 2 other examples, and those 2 examples are based on bigger companies acquiring smaller companies because they have a lot of intellectual property rights. Shall we say welcome to Lars again? Can we hear you now?
I hope so.
Yes.
Yeah. Well,
Good.
so I need to find out where we are now in our presentation.
Yeah. Actually, we moved on to the next slides. So the question is if you feel that you want to add something on the perspectives of IPR before I continue with Peppa Pig and Cinemax.
Did you cover some of these issues about the perspective?
I tried to cover them, but I'm not sure I said everything that you wanted to say.
Otherwise, we'll get an opportunity when we go further on. I think there's when we go to one of the later slides. I think I can come back.
Okay, good.
Just continue, please. Then, thank you.
Yes. So the examples of Peppa Pig and Cinemax. Well, these are examples of companies being bought. So Hasbro, the American toy company, bought the company behind Peppa Pig. And Peppa Pig is a children's characters. You have the films, you have the books, you have the toys. And Hasbro is an American toy company, and they bought the Peppa Pig company for $4 billion. And that's quite a lot of money. And in the Cinemax case, Cinemax, they are both themselves and owning companies creating computer games. And Microsoft purchased just some months ago Cinemax for $7.5 billion. And in both these cases, you could ask, well, what did they pay for? What did Hasbro pay for, and what did Microsoft pay for? Well, they paid for intellectual property rights. They paid for trademarks. They paid for copyrights. They paid for the know-how behind the creation of the computer games and the films for children. So you could see that this is a powerful business tool, and you could also see that it's worth paying for. And with that, I leave over to Lars again. Okay, so you're fine, but I can't hear Lars. So with this slide, we are talking about moving over to talk of intellectual property rights as part of an innovative process. So intellectual property rights, there are several different types of rights. So you have all different types of rights, and they can be used in part of the actual innovative process. So they can be obtained in very different ways. Some are obtained through registration, some are obtained without registration. The important thing is when you actually are starting to define what shall I do with my intellectual property rights, is to actually find out what is the actual innovation? What is the core of the innovation that I have here? Is it actually the technology that you could protect through a patent? Or is it the design? Or is it something totally different? And in asking that question, you should also ask yourself, what is the actual business case? What are people actually wanting to pay for? And moving on to the next slide, we have so the Angry Birds case. The Angry Birds is created by a Finnish company creating computer games, and the Finnish company is called Rovio. And they actually started out with what you could look at as really sort of forward-thinking intellectual property strategy. So if you look at Angry Birds, there's computer games, and computer games are protected through copyright protection. So that's the easy case. And what you normally would do would say that we are creating computer games, we're going to sell the computer games, and we protect what we have created through copyright, and people are going to pay for the computer games, for the copyright in using our computer games. But they created a totally different type of business model. They actually gave a lot of these games away for free, so that you could download them from App Store to your phone and don't pay for the computer games. But a business model building on giving something away for free is not really a good business model. So where did they earn the money? Well, actually, they started out immediately by thinking about merchandising. And if you look at Angry Birds, they have sold the rights to candy companies, to H&M to have the print on T-shirts. And there are actually different types of films with the Angry Birds. So the business model, they're giving some things away for free, some of their copyright protected material. But on the other hand, they are selling for the toys and everything and making the money there. Another example on the next slide is a Swedish company, is a Swedish pride in the digital world, Spotify. So before Spotify came about, you could either do the illegal way in file sharing or piracy, but the product that you sold was often records. So you bought the physical records to have them at home. What Spotify created is a way to stream music. And how can you build a business model on how to stream music? Well, what you have to do there is to write different types of contracts and agreements regarding the copyright. So you have their agreements with the record companies holding the copyrights, and then you have the copyright agreements with us as users. So their entire business model, their entire sort of creation, the entire innovative process is how to build that structure of the copyright agreements. With that, so we see if we can hear Lars now.
I should be on the phone now. I don't know if you can hear me.
Yes, we can hear you. Do you want to add anything before we go on to the do's and don'ts?
Well, no, I think I will jump in after the do's and don'ts, right? And then we can go back to some of the perspectives if we didn't cover it all, because I have not heard everything you said, Christina, but I'm quite sure you covered most of it anyway.
Okay. So then I'll continue to the do's and the don'ts. And these, we have grouped them in two. And actually, we're starting with the don'ts and then coming to the do's. So the top 10 do's and don'ts for SMEs when it comes to intellectual property rights. So often when you meet small and medium-sized companies, and you start to say, I'm an expert in intellectual property rights, their reaction would normally be, well, that's nothing for me, and that's not of importance to me. There's nothing there that I can do with intellectual property rights. That's not within my scope. But from my perspective, working with intellectual property rights is something that could be useful for all types of companies. So you see there is an example there of a chimney hood. And here we have one of the most interesting design cases in Swedish law in the last decade. So there was a small company that created a design for a chimney hood and actually filed for a design protection for the design of that chimney hood. And a competitor started to sell, but they didn't really understand that it was protected at all. So starting to sell similar chimney hoods. And the small company actually went to court and won in court. So therefore, probably most of the companies working with design of something like a chimney hood, they would not think of design protection. But as you can see from this case, which it went up in court and the company won, this is something that could be used by everyone. So all types of industries could actually have the use of intellectual property rights. So it is useful for all types of companies. Moving on to the next slide. And here we have an example which is quite common, even sometimes when small and medium-sized companies are getting help from someone. You can use different types of consultants to help building business models and so on. And the perspective is often that you can hear someone say, oh, but you have a technical invention. Oh, you can patent, and therefore you must patent. So if it's possible to patent, you must patent. But, and of course, patents can be really, really useful. Sometimes you can see in business press that if the time frame of a patent is running out, that can affect how much people are willing to pay for the shares in a company, for example. So patents are really, really powerful. They can build a company through having a strong patent protection. But you must have a plan for what you want to do with your patents. Why should you patent? What are you going to use the patent for? Are you going to license? Are you going to use it to protect against imitation, for example? So what are you going to do with your patent? Another thing with the patent protection is that it's really strongly linked to where you have the patent protection. So let's say that you have a patent protection in Sweden, then it's not protected by patents in Germany or Denmark or Finland. It's just protected in Sweden. And that leads to the question that sometimes companies file for patents in very many countries, and they don't really have to. They're just spending money on applying for a patent in countries where they don't have a use of the patent protection. So you should really have a strategy for what you are doing. And even large companies, large industrial companies, they do not file for patents in all countries where they can file for a patent because it's not useful. Which markets are they themselves interested in? Where do you have companies that could actually produce what you have protected through a patent? Those are the types of questions that you should ask yourself. So not just file for a patent in all countries where you can file for a patent. Another question is when you should apply for a patent. Sometimes people are starting to file for patents too early. And what I mean by saying that they apply for patents too early is that they haven't really thought about or finalized what the invention is and what the business case is. So when filing for the patent, it's described in not the perfect way for what they actually are taking to the market. And then they actually might end up in a situation when the patent does not cover what they actually need to have covered. And making such mistakes when it comes to especially patents could lead to an example that I hear quite often saying that patents could be the most expensive piece of paper that you have. And as in all cases, if you have expensive pieces of paper, they should also create value. So do have a strategy for what you want to do. Moving on to the next slide, we have the point of agreements. And sometimes when we talk about intellectual property rights, we're just talking about the actual rights, the registered patent, the registered design, the registered trademark, or the copyright protection. But in order to create what we wanted to create here, we wanted to create things with value. And the thing is that no business is an island. So in order to create the value in the intellectual property rights, you probably will have to involve more people. And especially when you're part of an innovative process, you often have a lot of people involved. Several inventors, if you're going to make computer games, there are a lot of people involved in creating the computer game. And lawyers are not always popular, so people might want to avoid to call the lawyers. And they start saying things like, but we have an agreement, we have an understanding. So we'll wait to involve the lawyers because they always complicate things. But the problem is that if you don't have agreements or written contracts, you might later on be in a situation which is much more complicated. So the don't is think we have an agreement. The do is do actually use contracts and agreements. And one thing with using agreements is that when you are going to negotiate the agreement, when you start to discuss what should we put into the agreement, you could actually use that as a tool to make sure that you share the same vision. Let's say you're starting a company with someone, so you're two persons and you're thinking, oh, we shall do this and we should do it together. Let's say that one of you, your vision is to create a company that can support your family. So you're going to work in that company, go in concern and produce something and you're going to sell it. The other one in that relationship could have the perspective of the Peppa Pig or the Cinemax. So they want to start with a startup and then go to a scale up. When you have this scaled up, then you're going to make an exit and make a lot of money. Those are two very different perspectives on running a business. So you have two different visions. And those two different visions will also lead to different ideas on how to use intellectual property rights. So when you start to discuss how shall we create a relationship between us, you can start to discuss those issues. And then you can actually perhaps even come to the conclusion that you don't agree. And then perhaps you shouldn't go in to business together, or you should create another type of structure for your business. So that's one perspective. Another perspective is that you use the agreements to create the framework. So you build the structure regarding your business. For example, in the Spotify case, without the copyright agreements, a tool like Spotify would only create infringements. So they will have to have the contracts and agreements there. Otherwise, their business would be illegal. So through the contracts and agreements, you create the framework for your business, which is quite useful. And also like the Zumba case. When you talk about the Zumba case, well, they registered the trademark and then they are licensing that trademark and creating the structure saying we want the instructors in class to behave in this way and use this type of music. And then they can do that in order to preserve the concept that they actually create and with the values that they think are important. And in many other cases, especially if you have children, many children, and I was one of those, ask for forgiveness rather than asking for permission. And in many other cases, it is easier to ask for forgiveness. So, oops, I screwed up. But when it comes to intellectual property rights, it is much easier to ask for permission than to ask for forgiveness. For example, we have cases where you could see that they try to negotiate the right to use specific music or a specific photograph after having started to use those photographs or that music. The problem is that your position of negotiation is not very strong if the other party can realize that you're sort of painted yourself into a corner, because you will have to accept whatever price they are claiming, for example. and you've already created an infringement. So asking for permission, may I use this photograph? May I do this? Or may I do that? Or shall we have an agreement on how to use the same trademark for both our businesses, for example? That is much easier. And you can actually, in most countries, you could make that the easiest way of creating agreements. And then you could write down afterwards, you could ask for it face to face or over the phone, and then write something, an email or a letter confirming, from our phone call, I believe we have agreed on this. And that is the really easy way to create some type of agreement. So moving on to the next slide. And this is an example of sometimes when talked to especially small and medium-sized companies, they focus on one IPR. They register a trademark and then they focus on the trademark. Or they have a patent and they focus everything on that patent. So they think about often as having one innovation means one intellectual property rights. But if you look at things like an iPhone, for example, you have several hundreds of patents within one, what we as customers believe as one product. And you have all the copyright and the trademarks linked to the apps and to the actual iPhone. So you have, for what we believe as one product, you have several different intellectual property rights. So the don't is to think about one intellectual property rights. What you should do is actually to create a portfolio or building an entire package. So use the entire toolbox. And one example of that is the link between patents and trademarks. We have a company, it's no longer just a Swedish company, AstraZeneca, and they are in the pharmaceutical industry, and for pharmaceutical companies, patents are really important. And then you could think, well, if you are in the pharmaceutical industry, then they focus on patents only. But they are often, when it comes to registration of trademarks, they're often in the top of the lists of registering trademarks also in Sweden. And the use of trademarks linked together with patents, then you can think about what are customers interested in, for example. So our patents could be interesting for us as customers, but when we are discussing, am I going to buy a new car? I'm not going to discuss, well, the patent number, I'm going to focus, I'm going to buy an Audi or a Volkswagen, for example. So the trademarks are useful. And trademarks also have a longer duration than the patent protection. So you can create the relationship with the customers during the patent protection period, but then you could use that relationship afterwards in having built the trademark during the patent protection period. Another example is that you could link together trademark protection and business secrets. So trademarks, I mean, those are the names that we use for different things like Coca-Cola or Pepsi. So from one perspective, you register the trademark and then you have the trademark protection. But the trademark is used to build communication, build a relationship to the market and to the customers that you want to reach. And in doing so, you often have built up knowledge on consumer behavior, for example, such as if we use these types of words, we attract these types of customers. If we use in our trademarks these types of colors, we attract these and these types of customers. So when thinking about trademark protection, you could also have the strategies behind them protected as business secrets, protecting that commercial information that you may have, but that your customers do not have, or your competitors, sorry. And then another example is design protection and copyrights. And design protection, if you create a design, you could often have several different protections. And you could have design protection, which is a registered protection, and you have another registered design protection as well. One example of that is the stock share for children from a Norwegian company. And when the duration of the design protection is not as long as the duration of the copyright protection, but when the duration of their design protection was running out, companies started to make copies, but the company could claim that these designs are protected under copyright. So they could block those copies as well. And I have another example that has been in Swedish courts. This is a mini maglite flashlight, and we have seen it in courts regarding copyright and trademark protection, but also under marketing rules. So you can use several different protections. And I can see that we have a question in the chat when it comes to registering protection and linked to patents. When companies from the Balkans, so the question comes from Albania, and saying that it's too expensive to register patents through EPO. And the question is, and first of all, patents can be very expensive to register. And that's also why you need to have a strategy for entering into registration, because it can be very expensive. And then so of course you would have to think about how to register. And the question is also if there are funds for new inventors, and there are both at European level, but also in different countries, different funds where you can apply for new for funds that could be used for registering patents. And also, if you build up and describe your business case, saying that we believe that we have something that could be protected through patents, but we would want you to invest in our invention, that could also be something that is attractive for other types of investors. So I hope that answers that question. And moving on to the last slide of do's and don'ts.
Sorry, can I just compliment a little bit on that?
Yes,
as well?
For Lars.
Because the question also refers to the EU IPR strategy, and perhaps it's in this context useful to say that the Commission is currently drafting on a new strategy. We have not yet seen, I think, a draft of it, but we have contributed to it, and we have also asked the Commission to consider incentives for SMEs to use IPR to have greater access to patents, for instance. So we have yet to see what will come out of this work, but we know actually it's a good timing. Is right now to try to get involved and to see if you can actually do something about this here now while the Commission is drafting.
Yeah, good compliment, Lars. So the last slide of the do's and don'ts. And this is also the lawyer perspective, and thinking that the intellectual property rights and the protection is something that you leave to the lawyers. And often when you have this type of perspective of saying, oh, that's sort of icky legal stuff, I'll leave it to the lawyers. The thing is that when you have that perspective, you also start asking the questions too late. So a vision a lot of people have of an innovative process is that you come up with a creative idea, and then you do your process, and you do your prototypes, and your experiments. And then in the end, when everything is finalized, then you start thinking about the intellectual property rights. And then you talk to the lawyers or the patent attorneys. But the problem is that that type of innovative process is often not valid anymore. It could be valid. For some types of industries, it's still valid. But for many types of innovations of many types of companies, the innovative process is rather circular. So that you have people coming in for a period of time, and then they're exiting, and other people are coming in, and you actually launch something to market, but you keep developing your business idea. Let's look, for example, at the innovation of Facebook, for example. Facebook today is not what Facebook was 5 years ago. It's not what it was even when it was started out. So you need to think about these issues all the time. And it's also part of the innovative process, and creating the business model. So what you should do is that you should think about these intellectual property issues as a business tool. Back to the examples of Spotify, back to the example of Angry Birds. So you could use intellectual property rights in actually creating the business model. So don't leave it just to the lawyers in the end, where you're almost decided already to enter into the market, but involve the lawyers early, especially start thinking about these issues early on in your innovative process. And with that, we're leaving the do's and the don'ts. I'm handing over to Lars and the next slide.
Thank you very much, Christina. I will do a little bit of catching up because because I had some technical difficulties, I did not hear everything you said, Christina. So perhaps if you will excuse, I'll just go a little bit back on the perspectives of IPR first, and then I'll come to this slide where we are right now. I think it's important for us to say that IPR is not only about protecting. It's not only about building the fences. It's also about building bridges and activating your opportunities to grow. And this is where we see IPR as an important tool, a strategic tool that you can activate when you want to activate your what we can call also knowledge-based assets. So for us to see when you start a business, when you run a business, and if you actually obtain IPR, this is also a token of your creativity. Your company is actually in a position to come up with something that is innovative, is creative, and is not seen before. So it is actually worth protecting. This shows that your company, your business, has potential to provide solutions to new problems. And that in itself is something that brings branding value to your business and actually can help you grow. It helps you stand out from your competitors, and it also it improves your market position. Also, activating your knowledge-based assets is actually also a way of provide a stable income through licensing agreements, sales, or spin-offs. That is also an important issue. And then, especially for SMEs, the IPR can be very helpful when you seek financing from external partners or when you seek to go into partnership with another business. Sometimes even another business with a complementary IPR, so you can actually work together. Or you can also use IPR to attract resourceful employees or even some of the talents that are looking for an interesting place to work. Also, I think it's important to mention that IPR is also something that will help you in your further development. This is what we call freedom to operate. When you have IPR, you have also established a field of freedom to operate. So you can now further develop in that area, and it can also help you on your growth journey then. It's also important for you when you are innovative that you actually check that you do not collide with other businesses' IPR to make sure that you do not have to spend all day in a courtroom, but you can actually continue what you do. So for us, this is important to mention. Also that IPR, it's a part of your business. It should never be the end goal of a company or business to own IPR. IPR should be seen as something that you sort of obtain along the way because you actually have developed something that is innovative and creative and actually allows you to protect it. Now, coming back to this slide where we are right now, I recently came across a diagram that showed the proportional market value of intangible assets in the S&P 500 index. And it showed that it has now moved or increased from being about 20% in 1975 to now being more than 80% in 2015. So in about 40 years, the proportion of intangible assets, the value of intangible assets has increased immensely. And when we look to Europe, we see that the general picture here is that the largest companies, they are the most frequent users of IPR. But we can also see a very clear correlation between IPR ownership and growth. The IPR Intensive Industries, that is defined as the definition covers companies that have sort of more than the average owner of IPR. They generate about 45% of European GDP. So this is a relatively small proportion of companies, businesses in Europe that generate almost half of European GDP. What we can see from the numbers is also that SMEs are more reluctant to use IPR. But the results from some of these studies that we have seen, and some of these studies are carried out by the European Patent Office and the EU IPO, they're quite compelling. They clearly show us that when you compare SMEs who have registered one or more IPR with SMEs who have no IPR, then you will clearly see that the former category actually experience much higher growth. And this picture is basically showing us that the more IPR you have registered, the more likely you are to experience high growth. And this is actually even in spite of what Christina just said, that you do not have to patent everything, but we can also see that it makes sense to patent when it's worth it. So even if SMEs are on a smaller scale compared to the bigger companies, the evidence is clearly that we have a clear correlation between IPR ownership and growth. And this is something we think is very useful or necessary for SMEs to consider carefully. Now, if we move on to the next slide, both Christina and I, we are employed with business federations with the clear mission statements to seek to improve framework conditions for the companies that we represent. And a very large proportion of our member companies are SMEs. And it is our very strong ambition that they should also have greater opportunities to benefit from IPR. Therefore, in this final slide, we have set out some policy recommendations which we would consider we present to those politicians and civil servants who are most actively involved in SME policy, and also now just mentioned before, the Commission is currently drafting a new EU IPR policy, and we have also, as members of the Business Europe, presented this to the Commission. Now, just to mention a few of these, I think it's extremely important that we have a very coherent and comprehensive horizontal EU policy. what we sometimes see is that IP policy is sort of set aside, or is treated as a simple subject within the single market policy. We want it to be an integrated part of R&D policy, all the way through to innovation, to industry and trade policy as well. IPR plays a role in all these aspects, and it should be play a more horizontal role. Also, from an SME perspective, when you sometimes question why they do not use more IPR, the answer is often that they are not aware of it, or they think it's very costly, or they think it's extremely complex. And yes, to some extent, they're right about price, about costs, and they're right about complexity. But it's also something that you have very skilled IP attorneys, IP lawyers, who can assist you in all these aspects and all these questions. And like you use consultants for other parts of your business to lean your business, or to when you want to enter foreign markets. I think it's important here that you actually consult with some of these IP advisors to seek their view, and also to seek their help on how you can protect, when you should protect, and also why. I think Christina already covered some of this. Then in relation to the question we had before, I think it's important also to promote incentives for SMEs access to IPR. Some of this could be tax deduction schemes, something you have at national level. For instance, here we have actually proposed here to have this deduction scheme for the use of IP advisors, or for the use of for buying IP advice for SME companies, which would allow you to deduct the costs, and then in the expectation that you would later on your company actually will grow from this. Also, we have, I think, some of the important issues that we have covered here, that we have taken on board here, is our recommendations on enforcement of IPR. This is something that often also is a reason why SMEs do not protect their IPR or their IP, because they're simply concerned that they will have to spend too much time, too much money on defending their rights. So we need to look at how we can have improved access to enforcement for SMEs, and here we also need to consider how compensation is actually how you compensate SMEs when they actually defend their rights in court. We often see that they might win the case, but the compensations do not really match the loss, and therefore it does not really pay off to go and defend your rights. So that is not a situation that is useful for SMEs, and certainly not something that we want to see in the future. Then also a few other issues is that we think it's important that we have a high-quality framework of IPR, and the European framework, not to say it's the best in the world, but we have a good high-quality framework in the world that we also need to expand to other countries in third countries. And then I think the last one that I want to touch a little bit upon is when you have often these partnerships between businesses and universities that also involves technical development, technical innovation, and often you see after that some concerns or some difficulties about how you should actually distribute IPR. We have a quite clear recommendation here, is that universities should never own IPR that actually comes from business or from partnership with a business. It should always go to the business, because that's how you can commercialize the IPR and the inventions. Okay, I think I'll stop here. Christina, are you back? Are you with us now?
Yes,
or?
I'm still with you. And there are some questions and comments that have come in. And I'll start with one that mentions the use of patent searches. And we can say patent searches can be done for various reasons. One reason could be to find a freedom to operate, to make sure that you are not making an infringement when you're using your invention. And there are different types of projects and how you could make it easier for example, small companies to do that types of patent searches, and you can get help with that. But I would like to emphasize one more thing when it comes to patent information and patent searches. And that is the perspective of that you can actually do searches in, for example, a SPASnet, to see where is the level of innovation today. So you could use that as a tool for inspiration, for example, and that should be used a lot more. So you could use that proactively. Another question that has come in is when it comes to SMEs in the digital sector, talking about copyrights, for example. And I think the most important thing when it comes to the digital sector is, for example, with the examples of Spotify and the Angry Birds, is that you normally have a lot of people involved. And that means that you could have so many different right holders. So especially there, it is important to keep track on who has done what, and make sure that you have the agreement so that you could actually use what, perhaps if you're this small company, you have paid people to do different things. But if you don't have the agreements there, then you cannot perhaps use what you have paid for eventually or in the beginning. And then there's a question, I think, mainly to you, Lars, regarding universities and own IPR from research partnerships.
Yeah, I think that's the last one I just touched on. Is when you have these research partnerships between companies and universities, often what we experience is that there's a dispute afterwards about who should actually own IPR. Universities often think IPR is worth much more than it actually is, which means that it's quite costly for the companies if they want to obtain the IPR fully. Often we do not know how it can actually what's the commercial value of the IPR is. And for some universities, this is a question that they want to bring forward, and it would be much easier, in our opinion, if we just simply allow only the businesses to obtain the IPR, and universities then they have contributed to it, but they cannot own the IPR. I hope that sort of explained the recommendation.
Yeah, thank you. So I think we can sum up. Thank you very much for this opportunity.
Thank you.